very small scale, and they supply the same to the British officer for use in their bungalows and to the missionaries for use in their hospitals and houses. But commercial mining of coal in Jand Hills district was started only in the early 70s. But the damage that has been done to the environment is indescribable. Rat hole mining, as Mr. Vargas has just mentioned, rat hole mining of coal has put the entire area under threat from earth collapse in the event of an earthquake, because mining was done underground, and because of the practice of rat hole mining, the effect of coal mining on the environment is also of a huge magnitude. There were reports of land crevices in the different parts of the state, especially in the East Giant Hills district, due to rat hole mining. It was reported that the crack on the entire market area of a village called Sokampar appeared due to the exhausted underground mining of coal. And again, sign of land underground caving in was noticed when a building at Rambai PHC began to crack. Water bodies in the entire mining areas are affected, and rivers were polluted, and all signs of aqua life in the rivers have gone. NEPCO, NEPCO is a electric generating agency of the government, reported that the acid water of the rivers in the coal mining areas are affecting their power plants, and the machines are exposed to river water has unnaturally corroded all the machines, which in turn has an effect on the expected lifespan of the Kupli hydroelectric project on the Assam-Meghalaya border. The absence of regulation on any kind of mining in Meghalaya till date is the main cause that led to the rapid environmental degradation in Meghalaya. Mining in the state is illegal because mining activity, except mining done by the cement companies, was carried out without any environmental clearance by the local people, the tribal themselves, and nor did they seek any kind of permission from the state or the central government agencies. Some limestone miners in Meghalaya only receive NOC from their respective district councils, which does not even have the mechanism or the wherewithal to check and control mining, which rendered it incompetent to issue any NOC. Moreover, as per the 6th schedule of the Constitution, mining is not a subject of the district council, but the district council, under pretext that land and rivers are district council subject, provided this authorization and authorized rampant mining in the state. Mining in Meghalaya is in a total chaos because neither does the national mining or the forest or environment laws are being implemented in the state, especially in the mining areas done by the tribal people themselves. And like as Mr. Verghese has mentioned, because most of the land is owned either by the community or by the land, or by the private person. And moreover, even in the community, like Mr. Verghese has said, even the community land has been appropriated by certain people who has has influence in the clan. The state has come up with its own mining policy recently, but the same is yet to be implemented. The two major issues which contribute to the rapid degradation of the environment in the state are the absence of regulation, whether national or state, to manage and control mining in the state. And the other reason is this misconception of the tribal people in the state that because Meghalaya is a Schedule 6 area, which has its own traditional land system, hence the native of the place has the freedom to do whatever they like with the land. Coal mining was never a traditional practice of the people. They seldom use this mineral for their own use, and neither did they use it for smelting of iron, or that the Khasi are famous of since time immemorial. It is also unfortunate that the state is also losing the exotic caves in the area to mining. There are hundreds of caves in the state and that has been surveyed and mapped, and these are all under the threat of being damaged, and some are found to be on the list of the longest and the deepest caves in the country. But all these are going to be history if the state is not interested in protecting the environment. In the case of Meghalaya, both district council and the state has failed in their duty to protect and preserve the environment. Rivers is the subject of the district council as per the 6th schedule of the constitution, but unfortunately all rivers in the coal mine areas, particularly in the 2 districts of Giant Hills, have become dead rivers. Empowering the district council, which has failed, is, it's not going to be a solution. Most of the members of the ADC, or the Autonomous District Council, particularly in Giant Hills, have very less education, and most of them are coal mines owner themselves, or they have stakes in mining business in the area. So mining is a very critical issue, and the state government, till now, it's taking it very lightly. In my opinion, I think we need to find some way to stop this rampant destruction of the environment in the area. And this matter is very urgent. Thank you.
Okay, it will take some time to get the PowerPoint ready. Let me begin with a little preliminary introduction. What am I going to speak? Mohrmen talked about Gentia Hills, and I will be speaking about Garo Hills. What I'm trying to present is trying to capture the reality of land rights in Garo Hills. I may not succeed in connecting this with the theme of the workshop, environmental protection, land rights, and so on, but I'll try to capture the diverse voices that are there in Garo Hills. So that's the attempt that I'm making. Now, I tried to get this data quite fresh, trying to write an article for a journal. So since the organizers requested me to do a presentation, I'm titling it as Overlapping Jurisdiction Between the Modern and Political Land Holding Authorities. Yes, there it is. Can you?
Just tell us when to advance this.
Just next. Yeah, this is the structure of my presentation. I begin with, I start with the changing, shifting land rights, what Mr. Varghese talked about. I start with that, from communal to individual land holding system. That's the starting point. What led to it? What are the reasons, factors? That's the first point. I'll deal with it rather extensively. Second is, I'll try to capture what I mentioned, the conflict of jurisdiction between ADC is Autonomous District Council, or 6th schedule provision that erects this particular ADC, and the Nokmas. Nokmas are the chiefs, Garo chiefs. There are supposed to be about 1,400 Nokmas, and the land that is owned by them or managed by them is Akhang. I will be using that word repeatedly, Akhang. Nokmas are put it as village chiefs. And the third, that's a major third part of the presentation, suggestions to improve land administration. And these are the 4 or 5 suggestions that are proposed that I'll be discussing. And most of the time I'll be trying to reflect the voices from the field. That's the attempt. I'm not trying to analyze, perhaps I do a little bit, but mostly trying to capture the diverse reality from the field. Next. Sure. Yeah. The previous. Yeah. These are the points now. Shifting land rights, meaning introduction of patta system. Patta system is individual land ownership. Patta is a word that is used, so I will be using patta repeatedly. That refers to individual land holding document. So the first point there, why patta system? Patta or land holding document stops encroachment on land from non-tribals, Garos from outside, and native Garos from inside. Three main topics. Why are people wanting patta system? Why is that craze for individual landholding documents? Very clear. From non-tribals, though it is, we know that the 6th schedule gives protection of land that non-tribals cannot own, but we know there are ways of handling this. So to stop that, people are going for patta system. Garos from outside. We know that Garos are not only in Meghalaya, they are in Bangladesh, they are in Assam, they are in Nagaland, they are in Tripura. So a lot of Garos tend to come inside Garo Hills districts of Meghalaya. So they tend to get inside and start getting a small piece of land, and then they say, we want a piece of certificate to say that this is our land, because they are from outside. Now, when the Garos from outside come and get a patta, Garos inside itself will get more and more threatened. They don't have, because it is a communal property arrangement that is there, they don't have a document with them. But Garos from outside, when they get inside and get a piece of certificate saying this is my property, the Garos inside get threatened, and therefore many have gone in for patta document.
But patta means a lease.
Yes.
Now the leaseholder is who is the owner? Who is the legal owner? The state.
Yeah, that is a conflicting issue. I think. Yes.
Or is it is it a communal property? Therefore, the legal ownership is not the state as such, but.
Yeah, I think this is a controversial issue. As the presentation proceeds, you will get to see yes. Native Garos. Again, I think Professor Varghese, Mr. Varghese, as well as Mohrmen made that point. There is this internal land alienation that is taking place. Those who have money would like to have more land, and especially in the context of extraction of minerals, whether it is coal, limestone, cement, and so on. So a lot of Garos who have money would like to have as much land as possible. So therefore, there is this internal land alienation within the Garo society itself, that which leads to class formation, and yeah. That's the first point. Second point, the Autonomous District Council encourages patta system. The point that you made, who owns the land? I've had chance to talk to different, various personalities of ADC, of traditional leadership, and the ADC would say the land belongs to the government, and ADC is the rightful authority owning it. So very clear to the ADC that land is owned; it belongs to the government. Come to the traditional ownership, the Nokmas, they would say no, government has no right whatsoever. Traditional land is ours. Village chief, Nokma, is the rightful authority over the communal property resources. So that's so now.
There's a further question,
yes.
Sir. The leaseholder, does he have any right to transfer the lease?
Yeah. Now, once the patta is issued, so naturally he has the right to transfer the land. So, why does a Autonomous District Council encourage patta system? Because there is revenue generation, tax collection. So that's a source of income for the Autonomous District Council. So if it doesn't issue pattas, the land remains the property of the Nokma, and Nokma is not bound to pay any tax to the ADC. So Autonomous District Council automatically says now the more income we have, the better. So therefore, more pattas, more revenues. So ADC encourages it. Third point, why more and more patta system? Banks demand patta as collateral. I think Professor Mr. Varghese mentioned about cash crops, rubber plantations that go on. In Garo Hills, in a big way, rubber plantation has taken deep roots. And for rubber plantation, or any long-term investment, you need to have money. And there was also subsidy that was provided by banks. And therefore, to get the subsidy, you got to have something to mortgage as collateral. So land would be that. But then here it is, common property resources, people do not have a piece of land. There was nothing to mortgage. So therefore, they were pushed to go to the district council, get the patta, get the document, and then deposit it as mortgage and get the loan. So therefore, that was the third reason. Fourth reason is development activities of government. So the development projects, especially road construction, lots of communal Nakma or Akang land, communal land was acquired by the government, rightfully so. Now, since this land was Nakma's land, common land, it went without any compensation. So government acquired it, used 1894 Land Acquisition Act, acquired the land, and no compensation was paid. So people think now, oh, there is a chance of getting compensation. Maybe if you have the patta, then you can claim compensation. So that was another reason why. May not be a very strong reason, but one of the reasons. 5, population increase. Less land, more people. Land-man ratio is decreased. So therefore, patta again. 6, patta system, patta leads to liberation from the control of Nakma. This is an important point. I will give you data in the next slide. Lots of people are wanting patta document because they will be away from the control or the thraldom of the Nakma. Otherwise, they are under the control of Nakma. Nakma will say, okay, you're owning this land. Next year, he may say, no, I want that land back. It belongs to me. You go get away to another piece of land. So Nakma can call the shots. So to get away from the Nakma's authority, many people would like to have land for themselves. And 7, common ownership leads to conflict. We know in a situation like common land where, okay, we may say things are nicely demarcated, but within a piece of land, there are chances that the one family claims, this is the land that I cultivated in the last cycle of June, and therefore I'm going there. Another party may say, no, I did that. So a lot of conflict that take place in common land can be avoided if I have a patta marked for myself. So therefore, these are the reasons that are put forward as reasons for attaining or obtaining patta document. What is it like? What is the feel in the district? This is a study that the organization that I belong to, we did about 3 or 4 years ago, and this is the roughly a sort of data that we have across. There are 3 districts there: West Garo Hills, East Garo Hills, and South Garo Hills. We chose about 15 villages from these 3 districts, 5 in a district. So 82% of the participants mentioned, yes, we want patta system. We would like to have individual land ownership. 16% felt unhappy, and 2% remained uncertain. Now, 82% who mentioned we're happy, I mentioned the reasons why they went for patta. Now, 16% who are unhappy, that I should mention. Why are they unhappy? They think that their traditional land ownership system would be affected, especially the culture which is tied to the land holding pattern, the entire Nakma system, the so-called Akang land. Akang land is common land. All this would be affected badly, and their culture would be affected. So these 16% fall into that category. And 2% remain uncertain. Fine, doesn't make a difference for me. That's sort of a unresolved issues. What are the issues that crop up from what we have said just now? Future of Akang land. It's a dilemma. I mentioned 82% and 16%. 82% saying we want individual ownership, which means Akang land would be simply Akang land has to make way for a patta system. But on the other hand, you have the traditional lobby saying, no, we want this system. There is this tension that's going on in the Garo society itself between the traditional and the modern leadership. What to do with the Akang land? We want the common land. Other groups saying, no, we want individual land because that has a future. We can invest, we can have more profit, we can have more autonomy. So that's the first issue. Second is, can Akang be recognized as collateral? this is a suggestion made by the traditional lobby. What are they saying? The banks demand the patta as collateral, but can the common property or akang land, can it be taken as a collateral? Which means if you take akang as collateral, then you need not go for patta system. So to stop that patta system, let akang, let the NOCMA issue a non-objection certificate, NOC, let that be taken as a collateral. Third, role of the district council contested. I will talk about it in the next slides. Yeah, the first point there, the ADC has been issuing pattas to those who produce the necessary documents. The next thing, it is good to explain the procedure. How does it take place? The ADC does not on its own issue the patta. The individual concerned has to submit the documents. And one of the important documents that the individual has to submit is the NOC, or the non-objection certificate, from the village chief or the NOCMA. He has to produce it. It is on that basis that the district council, land record department, revenue department would issue the patta. So there is a procedure that has to be followed, and in the beginning it is annual patta, 1 year, and it has to be renewed, and then what is known as periodical patta, 10 years, and so that's how it proceeds. And the ADC thinks they do very legal work. They act according to the Constitution of India, that is 6th schedule. What do the NOCMAs say? NOCMAs feel that the ADC has crossed its boundary of jurisdiction. I will repeat this point later. One of the reasons why 6th schedule was introduced in the Northeast, why autonomous district council came into existence, was to support the culture and the tradition of the tribal communities. That is one of the reasons. If that is one side of the story, the other side of the story is also 6th schedule was, or the ADCs were also a sort of a medium to lead these traditional political system into a democratic liberal institutions. That sort of a shift was also envisaged when this particular provision was introduced in the Constitution. What we see is a tension between these two. On the one hand, the ADC is supposed to safeguard, preserve, if you call it so, and support the culture and tradition of the Garo society. On the other hand, it is the same institution, ADC, is to lead this society, this Garo society, into modern liberal democratic institutions. So there is this tension that is taking place, and that's what the NOCMAs is saying. ADC is not doing the work of protecting Garo culture, Garo ethos. What does ADC has to say? The ADC insists that the provisions of the 6th schedule empowers with responsibility of regulating land management, which is so. The provision makes it very clear. So ADC says, we are very, very much within the limits of the Constitution. NOCMAs say that the 6th schedule advises the ADC to strengthen. I mentioned that. Okay. Let's listen. Next. Now onwards, I will just capture some voices of modern system and traditional system. This is, in general, the procedure. ADC works under 6th schedule. The administration of land, including parting of lands to individuals, is the responsibility of the ADC. But then ADC does not do this at its own will. If there is a settlement of some plot, that can be done only with the consent of the Akang people. Akang people is NOCMA. If NOCMA does not give his consent, no settlement can be done. This is a nice sentence, very nicely captures the reality. Administratively, the lands belong to ADC, but customarily or practically, it belongs to the NOCMA. So you're not listening. I think it is trying to answer your point, the last 2 points here, last sentence here. Administratively, it belongs to the ADC, but practically, what's happening there is it is NOCMA. This is an official from ADC, what he has to say. Entire land system in the Garo Hills is under the administration of Garo Autonomous District Council. Land belongs to NOCMA, who was under the administration, this is nice, who was under the administration of District Council. District Council has a right to give land on lease to those persons who are willing to obtain patta. District Council can issue annual patta or periodic patta. The amount prescribed by the District Council should be paid by the patta holders. I want to make a point here. When a NOCMA is, a new NOCMA is appointed, is elected, he has to be approved by the District Council, and that's why District Council says NOCMAs come under the administration of ADC. So therefore, NOCMA may have practical control, but NOCMA itself is under the ADC. Therefore, land is ultimately under the control of Autonomous District Council. NOCMA, one of the very powerful NOCMA that I interviewed, this is what he said. He's also a member of the NOCMA Council. According to Garo customary land tenure system, the ADC has no right to issue patta. How can they issue patta to a land owned by the NOCMA? The NOCMAs are pressurized by the ADC to issue pattas, that is NOC. We are taking the ADC to the court. Our